Good morning and welcome to Know Your Intellectual Property or IP rights in Festival Carnival Design. We have started our session today and I'm just going to pause for a few minutes to allow persons to enter the room. I see persons are entering the room and we expect a very large crowd today, almost 100 persons. So I'm going to wait for a minute to allow persons to enter. Okay, good morning and welcome again. I am Sharon Ligol, your moderator for today's session. I am a legal consultant and attorney at law with over 25 years of professional experience in the areas of intellectual property, corporate and commercial law, and the protection of traditional knowledge. This session is a collaboration between the Inter-American Development Bank, Connect Americas, the Trinidad and Tobago Intellectual Property Office, and our trainers and facilitators, Dion McNichol Stevenson and Nicholas Gaya-Prasad. You'll be learning more about both Ms. Stevenson and Gaya-Prasad later. Before I proceed with the formal part of this session, I wish to acknowledge all the participants from the Caribbean, North America, China, Morocco. Welcome all. There's another special welcome I wish to extend to Dr. Ganchev, who is the director of the Creative Industries Division of the World Intellectual Property Organization. The World Intellectual Property Organization is the United Nations specialized body for intellectual property. I now invite Karina Coburn, country representative of the Inter-American Development Bank, to offer a few remarks for us. Ms. Coburn.
Thank you so much. Good morning, everyone. And I just want to say a special word of thanks to our participants for taking this very important step towards understanding, managing, and protecting your intellectual property rights. I think it's important for us to start by thinking about what intellectual property actually is. Of course, this is going to be discussed in far more detail during the session, but simply described, intellectual property is a work or invention that is the result of creativity, such as a manuscript or a design, to which a person has rights and for which a person may apply for a patent, copyright, trademark, etc. Often these inventions are not yet physical in nature, but can still be bought and sold, forming part of a category of assets referred to as intangible assets. So these intangible assets actually have significant value. There are several international estimates of the value of these assets, and generally it numbers in the billions of dollars. Some estimates indicate that in 2021, the global value of these intangible assets was $74 trillion. And some say this is even expected to reach a value of 1 quadrillion by 2050 if current growth rates continue. So actually, this is big business indeed. I know that many of you, many people within the artistic space do not actually consider yourselves as business people as well. But if you wish to support yourselves and your families through your art, which is something that was unheard of for many artists even 10 or 20 years ago, then it's going to be important to develop not only your artistic skills, but your business skills as well. And at the core of that, especially for artists and people who are within the design and festival space, is that understanding of intellectual property and the value that you create when you produce designs and ideas. This course will cover the topic of intellectual property rights, as has been indicated, but also how to protect and commercialize those rights. And of course, there will be elements that are specific to the festival industry, which will also be highlighted. I invite you to take advantage of this opportunity to ask questions and take note of where to get additional information if you need it. I'm very happy to say that this course is being hosted within the Connect Americas platform, an initiative of the Inter-American Development Bank Group, and an important space for small businesses and entrepreneurs to engage with each other and identify potential partners, customers, and subject matter experts. Over the coming weeks, we will be building out more tools and services specifically for the creative industries. And a recording of this course will also be available there. So please go ahead and get registered on the Connect Americas platform if you haven't already. Registration is absolutely free. Let me close by saying a quick word of thanks to the TTIPO, with whom we first started discussing this initiative, I think almost a year ago, and we're very, very happy and pleased to see it coming to fruition today. Thank you also to the facilitators. I'm sure you'll find that they are extremely knowledgeable of the IP sector. The Connect Americas team, who is hosting the platform today, and my very own colleagues at the Inter-American Development Bank, Trinidad and Tobago Country Office, who have worked really hard to organize and promote this course. We're looking forward to a wonderful and engaging learning experience today.
Thank you very much, Ms. Coburn, and thank you for contextualizing it in the business, from the business perspective and the economics perspective. Thank you very much for bringing those remarks. And now I hand you over to Regan Asgarali. He's the controller of the Trinidad and Tobago Intellectual Property Office. There's a bit of information about Mr. Asgarali, but without further ado, I'll hand you over to him, the controller of the Trinidad and Tobago Intellectual Property Office.
Thank you, Dr. Legol. Thank you, Ms. Coburn. Good morning, everyone from across the Connect Americas platform and the region. A special good morning to Ms. Karina Coburn, Inter-American Development Bank's country representative for Trinidad and Tobago, Mr. Isaiah Williams, Special Project Management and Delivery Consultant at the IDB, Ms. Latoya Roberts Thomas, Communications Consultant at the IDB, Mr. Luciano Andres Gasparini Palladino, Integration and Trade Consultant at the IDB, and of course, our main facilitators, Ms. Dion McNichol, Mr. Nicholas Gaya Prasad, and a special also good morning to Mr. Lalu Ramlal, Head of Education, Information and Training at the Intellectual Property Office of Trinidad and Tobago. It is my honor to briefly address everyone, and I wish to extend my sincerest gratitude to our speakers, our presenters, for their invaluable contributions to come, and most importantly, for our stakeholders here today online. Steel Pan, Calypso, and Masqueraders are the three artistic pillars of modern-day carnivals, as expressed by Dr. Lester Ifibo Wilkinson. Today, the TTIPO, the Trinidad and Tobago Intellectual Property Office, the National IP Training Center, supported by WIPO, and the Inter-American Development Bank, embark on a journey to enlighten, educate, and empower those who are involved in costume and mask design for the carnival industry across the Caribbean region and the Americas platform, on the importance of utilizing the intellectual property system to secure and safeguard your creative expressions. The aim of the National IP Training Center is to provide education, information, and training services or EIT, in intellectual property to support innovation and entrepreneurship not offered elsewhere in our country and I dare say our region. The IDB is a most suitable partner in this regard under the visionary leadership of Ms. Karina Coburn. The IDB is, to quote, committed to addressing specific issues within our region. We not only intend to foster a culture of creativity and innovation, but we also aim to recognize the valuable contributions of our female entrepreneurs. We therefore encourage our female designers, our entrepreneurs today involved in the carnival industry, to immerse yourself in the learnings as we continue to develop the strength of our SMEs within the sector. Bearing in mind, some countries have already concluded their carnival seasons, and some are preparing for their upcoming carnival seasons. The timing of this webinar is perfect. It took a year to plan, but I think we got this date right, Karina. According to the study entitled The Economic Contribution of Copyright-Based Industries in Trinidad and Tobago by Dr. Vanus James in 2012, the broader grouping of steel band, music, carnival, and other culture produced TT 129.5 million, or 4.5% of the copyright sector's output, and employed 10.5% of its workers. We are working to update this study. Up to yesterday, Ms. McNichol Stevenson and myself, we had discussions with Dr. Ganchev and looking to update the study and delve deeper into the importance of this industry and what it generates our economies in the region and what it can further generate in terms of employment, our culture being spread from here and abroad. So therein lies the importance of this industry, to not only provide entertainment, but to create the employment opportunities for our citizens, to generate FDI for Trinidad and Tobago and other countries within the region. I would like to briefly mention the theme for the World Intellectual Property Day this year, IP and the Sustainable Development Goals, the SDGs, building our common future with innovation and creativity. It could not have been a more apt theme for today's session. This provides an opportunity to explore how IP encourages and can amplify the innovative and creative solutions crucial to building our future. In closing, I urge all to take the information provided in today's webinar and in the topics that would be covered and use it as a tool for your own development of your businesses and for us as a nation and as a region to really take our creative expressions to the next level. Thank you all, and I wish you all a successful session.
Thank you very much, Mr. Asgarali, and thank you for situating Carnival not as a creative endeavor, but also a potentially economic endeavor. So thank you so much for that. And at this stage, we will begin the sensitization session with our trainers. In addition to their other qualifications, they are both intellectual property trainers certified by the World Intellectual Property Organization. Okay, but before we get to the fun part, there's some housekeeping. Given the size of this session, your cameras and microphones have been disabled. If you wish to contribute, you are invited to use the chat or the Q&A. At the end of the session, you will be contacted with a link to a recording of the session. Also, at the end of the session, you're invited to complete a survey to let us know your views about today's session. I now hand you over to our certified trainers, Ms. Dion McNichol Stevenson and Mr. Nicholas Gaya-Prasad.
All right. Good morning, everyone, and thank you so very much, Sharon. Thank you, Karina. Thank you, Regan. It's really a pleasure to be here to kick off this inaugural training in this area. And I'm really happy to be joined by my co-facilitator, Nicholas Gaya-Prasad. And we're really hoping that you're going to have some fun with us today as we bring some awareness to what IP can do for you in your business as a carnival or festival costume or accessory designer. So I am Dion McNichol Stevenson. I have 25 years plus experience within the creative industry. Started out as a performer, became an attorney when I recognized that there were gaps in that area, and then transmuted that legal practice into a creative industries consultancy, where my mission is to demystify creative industries for entities ready for trade, and to also train and demystify intellectual property so that people recognize what it is in terms of a capital to drive for their business. So that's a little bit about me. I'm really happy to be here training, providing this, facilitating this training here today. And I want to introduce my very able partner, Nicholas Guy-Prasad. Nicholas, tell us about yourself.
Hello, greetings everyone. My name is Nicholas Guy-Prasad. I am a certified trainer at the National Intellectual Property Training Center of the Intellectual Property Office of Trinidad and Tobago. I am also a technical examiner here at the Intellectual Property Office, so I examine patent applications, I examine new plant variety applications, and then something else we will speak about a little bit later on, I examine industrial design applications. I have been working at the office for the past 12 years. So I have 12 years of experience, and I'm still learning. It's always good to continue learning. And I also am heavily involved in the public education aspect of the office, where I would usually go to schools and teach about intellectual property. I actually head up our Youth for IPTT section here at the office. So I really look forward to presenting to you all this morning, to teaching you all about intellectual property. As my co-presenter, I'm looking forward to working together with my co-presenter to ensure that you all leave this introductory session with something, with a bit of knowledge, with something that you could take in, you can internalize, and you can go ahead and express in your futures.
And I'll also add to that, Sharon mentioned a survey afterward. So if you're good and you answer the survey, you may have some takeaways to get. Okay? So let's go right ahead. So we want to say welcome again and thank you for joining. Thank you for coming. 3 things we want to know. Who's here? Who's here and who's who? So if you can tell us in the chat, I believe it's been enabled now. If you can tell us in the chat where you're from, show us your flag, tell us what you do. Are you a designer? Are you a producer of a mass band? What do you do within the carnival industry?
If I may, Dion, if you are unable to make your comments in the chat, maybe you could attempt to try the Q&A. Maybe you could try that if the chat is still disabled.
Both Nicholas and I were just able to indicate where we're from.
I'm seeing Abia said the chat is also disabled.
Okay. So is it that it's only enabled for the host? Perhaps we can have tech look at that for us.
For attendees. Eva is also saying for attendees as well.
Okay. So I'll put in the Q&A. Say we're seeing some Trinidad.
I'm seeing Nicole saying Trinidad designer.
Hi, Nicole. Hi, Nigel. Trini's up in your house. We have any visitors? What is Carnival if we don't have visitors? Oh, yeah. Okay. Carnival Studies student, welcome, welcome, welcome. Hello, Ava. All right. So it's looking like we have a lot of Trinis in the house. And I'm glad that you all are coming in. I know that we have some visitors with us. They probably just maybe a little shy, right? But you all make them feel free, make them feel welcome, okay? Because that's what we do, right? Okay. So when you registered, you would have been invited also to, this is the second thing, you would have been invited to fill out a little questionnaire. So I'm gonna ask Nicholas if he could share the screen of the results from the pre-assessment questionnaire that we sent out. This was us trying to get a gauge of how much you know about IP, so that we know who we're speaking to, so we know how to speak. Yeah? And we asked some pretty straightforward and non-difficult questions, like what is intellectual property? And the majority of us were able to say that it's a set of legal rights that protect creations of the mind. We also asked about copyright, what the term copyright refers to. And most of us got it correct that it is an exclusive legal right, given to a creator of a creative work, right? To do certain things and or to prohibit doing certain things. We see that we have a mixed pot of thought, mainly on the correct end where patents are referred to. And generally there tends to be some, in my experience, patent is the term that people seem to use most incorrectly a lot of times. So I'm not too surprised by this response here, but I'm happy that most of us were able to say yes. It is that exclusive right granted to inventors. And then we asked about trademarks as well. And again, overwhelmingly, we were able to say that is a recognizable sign. So we have a fair idea of what intellectual property is, or the very basis of what intellectual property is. And I think that gives us a solid ground to start on to kind of jump off and go a little deeper into how you identify the IP that you have and how you can make money from it. Okay, so that was our assessment. So thanks for sharing that, Nicholas. Right. And so, right. So we want to talk now about the objectives of today. And that's basically, it's going to be by the end of this session, what we want you to learn, what you want you to walk away with is knowing how to identify IP, how the IP rights can be protected, and how IP rights can be commercialized. So this is what's in it for you. This is why you signed up today. You signed up to be able to know how to identify IP, how IP rights can be protected, and how IP rights can be commercialized. Nicholas?
So before we actually get into the meat of the presentation, we have a quick video we want to show you all. So please allow me to share. Let me. Okay, so could you all see the screen at the moment?
Yes, we can.
Okay, good. Right, so here it goes.
Today we bring you our extraordinary Caribbean talent, Miss Andrea Mackenzie, award-winning artist, mixinator artist, owner, founder of Andrea Unique Art, where her stunning pieces are infused with the essence of her Caribbean roots and culture. Welcome, Andrea.
Thank you for having me.
No problem.
So Andrea, how are you? And you can just tell our audience a little about yourself, your background, your heritage, and...
Well, I grew up in Trinidad and Tobago.
Wow.
Yeah. My dad is actually was a big Carnival person. He owned Legends. You know, they won Banner of the Year 5 times. You know, my whole history is that my family is heavily into the arts, fashion designers, painters, whatnot. And my grandmother was also an artist and pianist. So from an early age, I kind of, learned to build costumes and make certain things, but art has always been a natural talent for me. With help along the way.
Yeah.
And only when I started to achieve certain things is when they're like, whoa, you know what I mean?
Yeah.
And I had to leave to expand, my horizons. So honestly, and mainly to help young girls in the industry, how to deal with certain situations and get their deals and
Yeah.
It's a lot.
I bet.
You know.
I bet.
You don't. It's not necessarily you could be a graphic artist. You could work for Nike. You could. I mean, art goes across the board.
And I think what you said right there is more or less turning art into what the business aspect of it. And I feel as though, hope nobody don't take this no type of way, but like stuff like art, right? There's a business aspect to it. And I feel as though stuff like that, we in Trinidad, is a hustle. Is a get by, and they don't see the broader aspect of it and what the world could learn from our little island and expressions from it. I don't think they see it like that.
I mean, there's so many layers. Like I want to show people that you could make a living.
Yes, exactly.
You could buy a house, you could invest your money into other things, just using your creativity, you know, but you have to do it the right way.
Okay, so that's it for our little bridge in video for this morning. And I will now turn back over. Well, actually, this is my section now. So, so it is my.
Nicholas, I just wanted to share why we shared that video. So Andrea McKenzie would have been one of my first clients as a new attorney in the entertainment law, intellectual property field. At that point in time, she was designing mass costumes for sections of mass bands. And she recognized, I may need to protect myself. These conversations and so forth are not sufficient for me to stand on or feel comfortable with. And so she came looking for contracts. But we showed it now to show the span of where she's at. And you heard what she said. It's layered, but you can make a living from it. She indicated that she had to leave Trinidad and Tobago to expand her horizons. We're doing this training to ensure that we don't have to leave to expand our horizons. If we leave, it's because we want to, it's because we're trading, it's because we're exporting, but not because we're part of the brain drain. Yeah, because we have enough infrastructure, information, and implementation to make it right here. Go ahead, Nicholas. Thank you. I just had to get that off my chest.
No, of course. Thank you very much. Okay, so it is my pleasure. Let me share the presentation once more. Okay, is it up? Yes. So it is my pleasure this morning to guide you all through the next few slides of this presentation. I am hoping that it would give us all a general understanding of the term intellectual property. It'll also go through a few key intellectual property rights that are most suited to those who are involved in costume and festival designs. And if anyone has comments, please feel free to type them. If the chat is open, you could type in the chat. If not, you could use the Q&A section. I am a very interactive presenter, so I appreciate it when persons chip in with their comments. So I would like to know if persons could maybe type a Y or an N in the Q&A or in the chat. How many of you have, or before this session, before that questionnaire went out, how many of you have ever heard of the term intellectual property before? So you could use a Y for yes, that you've heard it, or an N for no, that you haven't heard it. I see the chat is working, so great. So lots of Y's coming in. Lots of Y's. Great. So you're actually going to make my job a lot easier this morning. All right. So perfect. Thank you so much. Intellectual property, as a broad definition for the persons who are not aware of what intellectual property is, it refers to the expressed creations of the mind. Okay. You have an idea for something, whether it's a design for a costume, or maybe it's just a part of a costume, or you have an idea for a painting, for art, a sculpture, anything along those lines, and then you take that idea and you bring it out into reality, and you do so by sketching it, sculpting it, painting it, writing it, drawing it. That physical expression is what we call your intellectual property. So by using the Y and the yes again, how many of you have already, or you already have intellectual property by that definition? I'm seeing some Y's, I'm seeing a me. Great, great. So you are definitely in the right place. Elise, Julian, that's okay if you don't. This is a session that is going to help you and hopefully inspire you as well to go ahead and create. All right. Now on the screen you're seeing two pictures. You're seeing a picture of a monkey, and you're also seeing a picture of what I tried to represent as artificial intelligence. Now the reason why I have these pictures on the screen is to break down even further this definition of intellectual property. So we have the express creations of the mind, but we further break this down to state it is the expressed creations of the human mind. All right. The story of the picture with the monkey is that this picture that you're seeing was actually taken by this monkey. This is the famous monkey selfie case, and there was a legal battle between between Peter and the photographer, or the person who owned the camera equipment that the monkey used to take this picture, as to who exactly owns the rights to the picture. And we'll speak a little more about ownership a little bit later on in the presentation. But as a forward, when it comes to photography, the person taking the picture usually is the person that owns the rights to the picture. We will clarify that even further when we get deeper into the presentation. So by that definition, of course, Naruto is the one, the monkey is the one that owns the picture. Put that in quotes. However, the decision by the courts was that, Naruto is not going to be able to exploit or recognize or act on his intellectual property rights that come along with his rights to that picture. And again, we're going to speak more about the rights a little bit later on. This is just queuing up all of our discussions for later on. So because Naruto would not be able to do these things, Naruto does not own rights to this picture. Artificial intelligence, we are very much in the age of artificial intelligence and AI. AI is generating not just music for persons, AI is now generating scripts, AI is generating images. I saw persons putting in various AI generators, show me what the Taurus horoscope would look like in the Egyptian days, and they would get a full image of what that would look like. So AI is now being used to create paintings and works of art and drawings and sketches and stuff like that. However, this is not a human mind. Yes, it is creating, but it is still not a human mind. And there's a case as well that we would also link in the chat. I will ask Ms. Passad if she could do that for me. That further breaks down the decision by the courts as to whether artificial intelligence can own intellectual property or not. Long story short, they cannot. However, there are certain cases where persons have to disclose that they did use artificial intelligence in their creation. So it's a very heated debate at the moment, which we would probably answer questions for later down in the presentation. But for now, I just want you all to know that IP refers to the express creations of the human mind. So I like to usually show persons that I could attempt to create as well. Now that we have a basic definition of IP and how you go about creating something, our next step is to understand how we can protect our IP through the use of IP rights or intellectual property rights. It is important for us to understand that although you can say you created something, an intellectual property right is a legal instrument that provides proof that you are indeed the creator or the author or the owner of that intellectual property. And there are many types of intellectual property rights that we need to be aware of. we also need to be aware of the fact that these rights protect different things. So for example, this costume design is something I created. Don't laugh at me. I tried my best, right? Now, I'm not claiming to be an artist or anything. I literally had a concept in my mind for a band name. The band name is Wonder. And then I wanted to create a design that would probably embody this name. And this is what I came up with. By the end of the presentation, we will be able to identify which intellectual property right is going to protect the various elements of this design, or even designs that you would have already created. So I'm going to ask for a quick review. Type a Y in the chat if you think this is a good design, and type an N if you think it's a great one. So as I mentioned, there are, oh, I got a Y. Nice. As I mentioned before, there are different types of intellectual property rights. Intellectual property, Isaiah is on defense. Intellectual property is separated into two main arms. On the left, we have something called industrial property, and on the right, we have copyright and neighboring rights. It's also known as copyright and related rights. On the left, we have rights such as trademarks, patents, industrial designs, geographical indications, integrated circuits, and new plant varieties. On the right, we have everything that is protected or that can be protected under copyright and neighboring/related rights. Okay, we are going to go further into some of these rights in the presentation, but before we do that, I want to know, or we want to know, what is in it. Can you name some of the creative elements that are present in the carnival and festival costume value chain? And we're going to do that by participating in a little exercise. So I just posted a link in the chat to a Jamboard, all right? And for persons who are able to, could you please click on this? And you will be taken to a screen that I'm going to pull up right now. Okay, so a lot of persons are in already. Now, what I'm going to ask you all to do, you will see on the left side of the screen, there's a little panel, and there's a panel in the middle that says sticky note. If you click on the sticky note, you can type in here, you could change the color, and then you click save. So tell me some of the things that, or some of the creative elements that are present in Carnival Festival costume, in the Carnival Festival costume value chain. So I'm just gonna put just a random broad definition. I'm just gonna put design, change the color, and I'm gonna hit save. All right. So tell me what you all think are the creative elements that are present. Okay, so I'm seeing steel pan. What else do we have? I'm seeing arrangers, I'm seeing wire bending, I'm seeing Monday wear. I'm seeing gems, all right, yes, composers. I'm just moving around some stuff so I could see musicians, materials, feathers, beads. I'm seeing in the chat streetwear fashion and designs and creativity. Costumes, Calypsonians. Very good, very good. Thank you all. Okay, so I think this is good for us to go on at the moment. Thank you all very much for participating in this little exercise. And bring back up the presentation now. Okay, so I hope we had a little bit of fun with that. But now it's time to break down some of the intellectual property rights. But before we do that, let's take a look at some of the suggestions that we would have gotten. All right, so I saw someone put costumes, someone had music, we had design, we had bands, but we also have broadcasting, events and promotions, designers, photographers, photography, videography, performers, exhibitions, trade, publishing, production, artwork. All of these things are examples. So it's not the sum total of it. They are examples of some of the creative elements that can be found. Now, if I were to organize these things, food and drink, yeah, food and drink could be inside there as well. So if I were to organize all of these things, I would organize them into music, artwork, bands, costumes. Under music, we have scores, lyrics, arrangements, composers, producers, performers, broadcasters. Under artwork, we have drawings, paintings, sculptures, figurines, promotional material, graphic work, such as what was spoken by Ms. Mackenzie in the video. We have the bands, the brand of the bands, section names, theme names, sponsors, persons who are sponsoring the bands. Then in costumes, you have clothing design, we have masqueraders design, we have Monday wear, we have, of course, things like the kings and queens. Again, this is just a snapshot of some of the things and not the sum total of everything that will be found. But now, I want to take all of these creative elements that we are more or less associated with, or that we know, or that we would have already created, and I want to break them down even further, simplify them, I should say, even further, into these intellectual property rights. So we have copyright, we have trademark, we have industrial design. Copyright would cover things like your musical score, your lyrics, your arrangements, your composers, your drawings, and all of these things under this category. Trademark is going to cover things like your band logos, your slogans, your theme names, your section names, your sponsors' brands, your event names. And then under industrial design, it's going to cover masquerade design, set design, figurines, carts, pans, sticks, clothing, or beverage holders, handicraft, and jewelry. Someone had put beads and feathers and materials and stuff on the Jamboard. So the three intellectual property rights we're going to focus on today are copyright, trademark, and industrial design. So let's start with copyright and related rights, or copyright and neighboring rights. Copyright refers to the rights granted to authors, artists, and other creators in their literary or artistic works. So we would have seen a few slides ago a lot of things that fell under this category. What I'm going to do is I'm going to show you what those things are, just as a refresher. We also have neighboring or related rights, which are property rights that subsist in performances, broadcasts, and sound recordings. Now, I have a picture on screen with that says "Farm and Happy Big People Party." Who knows this song? Anyone knows this song? I wanna go big people party. That one, right? Now I put this song up because this is a good example of how we break down the difference between copyright and neighboring rights. I happened to be in a fete when this song came out. I can't remember what the date in which it came out, 2015, I think. And Farm and Happy was about to perform. But before Farm and Happy performed, he brought out three guys onto the stage and he said, you know, we need to thank these three guys because they were the ones that wrote this song. Which was a very, very cool thing to do, and also a very important thing to do, because what it did was it showed us that the three guys that wrote the song would be the authors of the song. They would have copyright in the song. Farm and Happy, for his performance of the song, would have neighboring rights. The production company who produced the song would also have neighboring rights as well. So we see on one song, three different parties enjoying rights on that one song. So that's a good way to help distinguish the difference between copyright and neighboring rights. So what can be protected by copyright? We have writings, audio-visual works, paintings, drawings, and engravings, sound recordings, musical works. I'm going to skip that one for now and come back to it. Illustrations, maps and plans, public performances, dramatic works, stage productions, sculptures, computer programs, photographic and architectural work. These are all of the things that fall under copyright. All right. So I'm seeing Mr. Ramal saying creations of the human mind. Yes, that's correct, Mr. Ramal. Yes. And Diana sharing some fun facts about herself in the chat as well. Now, under the Trinidad and Tobago legislation, or in the Trinidad and Tobago copyright legislation, we have a special provision for works of mass. A work of mass is an original production intended to be performed by a person or a group of persons in which an artistic work in the form of an adornment or image presented by the person or persons is the primary element of the production, and in which such adornment or image may be accompanied by words, music, choreography, or other works. So it's not just simply the costumes. It's much more than that. It's an entire production that would allow it to be called a work of mass. All right. So that was copyright and neighboring rights in a nutshell. All right. So by now, you would have be able to identify certain things that you would have already created. For those of you who created, that there's copyright, or you have copyright over these works that you would have created. Let me see a Y if you understand that you have copyright for some of the things that you have created, or an N if you don't because you didn't create anything yet. I mean, if I wanna just break it down even further, if you wanna go expand outside of the carnival industry, we would have been creating since we were kids, right? When we wrote our short stories, when we drew pictures and paintings, so I can't tell you how many cars and beach scenes I would have drawn as a kid. All right, and a lot of those things would have come from my imagination, not from something I would have seen, but what I would have wanted this to be. So copyright vested in those works, yeah. So industrial designs. Now this is the other intellectual property right that I want to cover. An industrial design protects the aesthetic or ornamental aspects of a product rather than its functional aspect. So basically it is protecting the way something looks and the way something feels rather than how it works. Okay? And industrial design is very relevant to a wide variety of products ranging from handicrafts such as jewelry to textile to fabric design, building design, bottle design, cart design, truck, anything that you could think of that you could possibly create a new shape out of, you could apply for industrial design rights for it. Okay. So as I said, protection of ornamental aspect of an aesthetic creation. I have on screen the very famous chubby bottle, which was protected by industrial design rights. We also have my costume, my Wanda costume, that could be also protected by industrial design rights as well. And then at the bottom of the screen, I have a picture of what appears to be a ruler. And this is actually it's called the Udazzle fashion ruler. And it's a ruler created by Miss Rona Jack, who is a seamstress from Tobago. And she was able to apply for industrial design rights in order to protect this ruler because it was a new shape of a ruler. It wasn't the way the ruler functions, it was simply the way the ruler looked. Okay. Now, in order for you to obtain industrial design protection, your design must be new and not disclosed, meaning you didn't have this design up for sale, you did not publish this design anywhere. It should also not be contrary to public order or morality. If you are awarded industrial design protection, you are awarded protection for a period of 5 years initially, and then you can renew that for 2 further periods of 5 years each to give you a possible total of 15 years. So your design must be any composition of lines or colors, any 3-dimensional form, any material, the composition of these elements must give a very special appearance to the product. Okay, so it can't be something like a basic shape. It has to be something unique and creative. So just to bring it into the Carnival context now, into the mass designers context, every year on Carnival Sunday, we in Trinidad and Tobago know about the Marche Gras, right? It's held to award the King and Queen of Carnival title to the best male and female masqueraders. Each band submits a king and queen for their competition and usually dons a costume more elaborate and more complex than the typical other masqueraders in the band. They're very visually stunning. I love seeing these designs every year. Love it. And designers compete against one another for the most innovative costumes. Why am I saying this? Whether you have designed a costume that is stronger or easier to maneuver, your imaginative design gives you a competitive advantage over the other designers, and it is definitely something that is worth protecting. So I'm seeing Tahila, after 15 years, would other persons be able to copy the design for sale? So after 15 years, the rights are expired. Okay, you no longer have sole ownership over these rights. But there are other things that you could put in place in order to help maintain persons that would come back to these designs. All right, and we will explain trademarks a little more in depth. That's just a precursor to trademarks. So a trademark is the intellectual property right that protects any sign, symbol, which indicates the source of goods or services. It must be a distinctive sign or symbol. It must not be a generic or descriptive sign or symbol. And if you are granted the trademark rights, it is valid for a period of 10 years, and this is renewable indefinitely. So you could renew this for as long as you can. For example, I think the brand Angostura is going on 100+ years of trademark protection. And if Ms. Passad is in the chat, she could confirm that for me. All right, so the name of the band, like if I go back to that title slide or that slide where I broke down the creative elements into and categorized them into the specific intellectual property rights, we will see band names inside there, event names inside there, theme names inside there. These are all things that you could trademark, all right? But you could also trademark things like appearance and motion, scent, shape, sound, taste, touch. So shape is a very important aspect here. Tahila was speaking about the 15 years the person's be able to copy design. If you were to apply for trademark rights for a unique shape, after that industrial design rights have expired, you would still have some rights on this shape. Right, so there are different things that you could employ to maintain the protection over a unique shape for as long as you can. Of course, each intellectual property right is subject to its own criteria, its own examination criteria. Okay, so these are just things to bear in mind. Also, different things that you could employ in order to maximize the amount of protection over something that you would have created. So we call these non-traditional types of marks because typically a trademark in the past would have been protecting things like your logos, your symbols, your slogans, and your names. But now you have the addition of appearance and motion and scent, shape, sound, taste, and touch. And a good example of one of these, sound mark, I should say, is right, so this is this is the first sound mark that was applied for in Trinidad and Tobago. It's Rembunction. I'm not sure how many persons would have heard this. I actually heard this sound on the radio, I think a couple of weeks ago during Carnival time, actually. So this is an actual protected or trademarked sound. So we are just trying to give you all as much examples as possible so that you could in the future, when you do create something, you are aware of the intellectual property right that you could utilize in order to protect what you have created. So why do you register a trademark? Question. Registering a trademark gives the owner of the mark a monopoly. That is, the owner has the exclusive right to use the registered mark on goods and services for which it is registered. Also, the owner of a registered mark can sue for infringement if someone else uses the mark or a similar mark in the exact same class. For example, the owners of the registered marks Tribe and Fantasy have the exclusive right to use their registered marks. I cannot use Tribe for my Carnival band. That's not my intellectual property. I don't have trademark rights on that. They would also have legal recourse should someone else use their marks without their permission. So let's just say I decide to print a bunch of t-shirts and put the brand Tribe on it, and even though I'm not associated with them, they could actually sue me for that because I don't have the right to do that. Trademarks also play a significant role with respect to branding. Various registered trademarks in the carnival industry have over the years attained a well-known reputation with respect to masks in Trinidad and Tobago. For example, mask bands are associated with designing some of the most unique costumes and providing revelers with an exceptional carnival experience. So this cues up this slide, which is the benefits of your trademark. Now, your brand, I should actually break down brands and trademarks. A brand is everything value-wise associated with your logo or your symbol. So when persons see your brand, they think, okay, this particular brand promises me a great carnival experience, all right? But the trademark legally protects that brand. The trademark gives you, the owner, the authority to license it, to utilize it wherever you feel the need to utilize it, and also to prevent others from exploiting it without your permission. So the benefits of a trademark: reinforces financial performance, gives customer choice when they see, or I should say, it also informs customer choice. It protects the use of logos and names and slogans and symbols. It protects valuable, or it contributes to the value of your assets. It builds trust and confidence and loyalty in a product. It could be used as a sign of endorsement, and it could also enable you to license this mark. I'm seeing a question that came in. If you're a mass band owner and you hire a designer, give them the concept and the materials to create the design, who will own the trademark? Now, this is a question that I think we should answer a little bit later on in the presentation when Dion gets into things like ownership and contracts and stuff like that. But it will also be answered very, very shortly. Dion would like to answer. Yes, Dion, you could go ahead.
Sure. If you're a mass band owner and you hire a designer, you give them the concept and the materials to create the design, who will own the trademark? Well, that depends. Haha, we heard that so much over the last two days, but it depends. You have once the person has created a design, the artwork is actually theirs because they have, although you gave them the concept, etc. We learned earlier that you can't protect an idea. So what you shared with them was an idea, right? But the finished artwork would belong to the creator of that artwork. In order for it to become a trademark, that requires the application process that Nicholas will speak to in a little bit, but when we get to protection. But in order, who files the trademark will be determined by who is the eventual owner. So we will speak to how we transfer rights and so later, but I'll stick the pin here to say the answer depends on who the rights in the artwork is given to, transferred to ultimately. So we'll discuss that a little later.
Thank you, Dion. Actually,